Hi, and thanks so much for joining us in the Talking Animals Law and Philosophy series. This is the first event of this new academic year, and it's great to have so many of you here with us today. My name is Raphael Fazell. I am the Executive Director of the Cambridge Centre for Animal Rights Law. When we start these types of events, I usually say a few words about the format for people who are joining for the first time. We will have a presentation by our speaker that will last for about 30 to 45 minutes, leaving us with around 45 minutes or so for Q&A and discussion. You're all warmly invited to participate in the discussion. I think the speakers usually get a lot out of it if some interesting questions and comments are being raised. So if you would like to participate, I would like to encourage you to use the raise hand function, which you can find under the reactions button on the bottom of your Zoom app. That will then allow me to give you the chance to ask your questions directly to our speaker or to make your comments. If you cannot locate the raise hand function, you can also use the chat box if that's easier for you, and I'll then just go through the chat. I will keep all the microphones muted until that point. We will be recording the presentation part of this event, however, not the discussion bit. So if you need to leave early, you can always watch the rest later on our website or send the link to a friend if you really enjoyed the talk. Okay, very good. Some more people joining now. Okay, with this out of the way, I can now introduce our speaker, and it's my great pleasure to introduce such a distinguished speaker. We have Angela Fernandez with us, who is full professor at the Faculty of Law at the University of Toronto, where she also holds a cross appointment at the Department of History. Professor Fernandez clerked at the Supreme Court of Canada after she completed her LLB and BCL at McGill University. She also obtained graduate degrees from Queen's University, where she studied philosophy, and Yale Law School, where she obtained an LLM and a JSD. In addition to teaching animal law, Professor Fernandez runs a working group on animals in the law and humanities. She is a member of the Brooks Animal Studies Academic Network and has been a member of the Brooks' Scholars Committee since June 2022. In a collaboration with Brooks, Professor Fernandez supervises the production of the Brooks Animal Law Digest Canada edition, which some of you may have on your radars already, and she oversees the University of Toronto's Animal Law Research Guide. For 3 years, she has worked with Brooks and Animal Justice Canada to organize the North American Animal Law Conference, as well as the Canadian Animal Law Conference. Today, Professor Fernandez will be talking to us about animals as property, quasi-property, or quasi-person. It's a presentation I really look forward to. Professor Fernandez, thanks so much for joining us today.
Thank you, Raphael, for inviting me. I've been a fan of this series for quite a while now. I've gone back and watched a few of the videos, and it's so great to be now included among them. I'm so happy about that. Okay, so I wanted to talk about the quasihood idea in relationship to both property and persons. Sometimes I call it the quasihood idea, just to sort of capture both of those aspects. And really my starting point here is the idea that property and persons really has been the dominant way of framing the status for non-human animals for quite a long time. I would say for at least about 30 years. And so perhaps unsurprisingly, proposed solutions to problems relating to non-human animals cluster around this idea that they must somehow be moved from property to persons. Their property status must end in order for them to have real rights. So that's the abolitionism that I know many people here would be familiar with. So this summa divisio, and we might think of it in French or civil law terms, this division between property and persons does come from Roman law and is expressed most concretely in civil law systems, which are inheriting directly and using directly the triad from Gaius of persons, things, and actions. So as many of you know, here in civil law countries, the code, the first book of the code will be persons. And so it's very foundational in that way. The classificatory scheme was brought into the common law in order to organize it it's, kind of notoriously sort of a jumble, organized in terms of procedure rather than substance. So a work like Blackstone's Commentaries on the Laws of England also used that tripartite distinction. In addition, Kent's Commentaries on American Law used a version of it as well. And like many classifications, it comes to almost be reified in a way that might be inappropriate. Okay, so if it's being used to sort of organize, should it really start to kind of exist in the world itself as a thing? And that's a question that we want to think about and ask about when we're looking at this. I like to quote here my supervisor when I was a doctoral student at Yale some time ago. Now, as Raphael mentioned, his name's Bob Gordon. He's a legal historian, and he talks about the legal concepts that are so deeply ingrained. They've soaked so deeply into the marrow of lawyers' bones. Okay, and property and persons is certainly one of those classificatory schemes, as is the tripartite distinction from Gaius. So these categories that we, lawyers and philosophers, think with, they are very difficult, if not impossible, for us to shake. Hence the proposal here to keep them, but in a mitigated or modified form, using this idea of quasi-property, quasi-person, or quasihood. The strict binary in its pure terms, property or persons, is not one that works well for non-human animals, who end up on the losing side of it, the property side of it. The idea then, as I say, has been to try somehow to move non-human animals to the personhood side. So either with an idea of moral personhood as laid out in the work of Gary Francione, or legal personhood as laid out in the work of Stephen Wise and the Non-Human Rights Project. The idea here is that we need to do this in order for non-human animals to have rights, because only persons have rights. These can't be just welfare rights, what I call small r rights, or Saskia Stuckey calls simple rights, but they must be capital R rights, or what Stuckey calls fundamental rights. Now, there are a number of problems with the personhood simpliciter strategy, but here I focus on the one that's most relevant to my quasihood argument, namely the very practical problem that when judges, or probably anyone for that matter, hear the word personhood, they automatically think human being. Okay, and why is that? Well, we've got, centuries of speciesism and human exceptionalism, it's very intrinsic to the humanities, or probably most of us are coming from. And this creates or triggers an outrage reaction, which is then followed by a kind of a shutdown, or really a no. And I think we've seen this happening on the whole with the Non-Human Rights Project litigation in the US, with the exception of some sympathetic dissents, for example, most recently in the case of Happy the Elephant. Now, the Non-Human Rights Project and Steve Wise are very careful to say that they're seeking chimpanzee rights for chimpanzees, or elephant rights for elephants, and not human rights for these animals. So, it's called Non-Human Rights Project. So, not asking for human rights. However, this message is confused and is confusing because the argumentation or the strategy is to bring evidence based on how similar these animals are to human beings. So their cognitive capacities, their emotional intelligence, their social behavior. And judges, will kind of they're not really quite sure, like, well, when you're saying persons, are you meaning human beings? Because you're saying they're close enough to human beings to be allowed in, but you're telling me you mean legal personhood just in the empty vessel sense of some rights. And so I think faced with that, they kind of go, I'm going to say no, because if I say yes, I don't really know what I'm saying yes to. Now, it bears emphasis here that the stakes are very high, because if personhood is rejected, then if you are subscribing to this binary universe in the Summa Divisio, what's left? Well, it's just property is left. And for those who are carrying just those two categories in the marrow of their bones, as it were, this is a bad place to end up. It's very bad for non-human animals, but I argue it's also unnecessary, given the flexibility that lawyers and philosophers have to reorient, redescribe, resist, in a way, really being colonized by the two categories, in the sense of thinking that non-human animals need to fit into one, but not the other. So hence the quasihood argument. The idea is to start thinking about them and talking about them as quasi-persons at least, and quasi-property at best. If they are to be property, well, then it is at best a form of quasi-property. And to do this at least in the short term, even if this isn't sort of ultimately where you would want to end up going and getting for them, this is a good place to start. It is better for them and describes the in-between space they inhabit in our human conceptual world, our legal and philosophical world. This is both a normative idea and also a descriptive one and a descriptive intervention. So what I'm going to do is, on the description side, outline how this works both for quasi-property and quasi-personhood. Okay, so first starting on the property side, the idea here is that the law already recognizes at least some non-human animals as being more than mere property. So they are a special sentient form of property, which, as the Civil Code in Quebec puts it, have biological needs. So that's a revision to the Quebec Civil Code that follows France. In civil code jurisdictions like Quebec and France, also Austria, Germany, Switzerland, and Spain, which have adopted not things provisions, they are still nonetheless keeping non-human animals like other property laws relating to non-human animals in effect. So it's not changing that property status. In the Quebec case, they're kept in the book on property. And so that's indicating also that they're still property. In Canada, our unnecessary suffering provision is in the criminal code, also in the book on property. Okay, so what is this? What is going on here? It's a sort of semi in between quasi kind of positioning. And the reason I'm choosing to use the word quasi is because it's a known and legal term. And it also is very accurately describing what I'm talking about here in the sense of marking a resemblance, but supposing a difference. So it's like a legal sort of. And there are a lot of legal concepts that use the quasi idea, like quasi contract or quasi usufruct is one in civil law. There's also quasi administrative and quasi legislative, quasi judicial. So it's really like a very known kind of word. Now, also on the property side, we have a lot of rules relating to companion animals, which are recognizing implicitly and even explicitly that they're not the same as mere property or other forms of property. So here we have animals being allowed to be the subject of trusts, animals whose best interests can be taken into account when there's a separation or divorce, damages for killing or injuring a non-human animal that exceed the narrow market value of the animal, also allowing animals to be part of protective orders in cases of domestic violence, or shelters that allow people to bring their non-human animals with them, even if they're required to leave behind other valuable forms of property. So these are all very like positivistic legal things that exist, which already recognize that animals are more than mere property. And as sentient beings, they are special forms of property, property plus, something like that. I'm suggesting to call it quasi, it's a little more neutral. Okay, and another example here would be jurisdictions which recognize the victimhood status of non-human animals and their inability to speak for themselves in a criminal abuse context. In Canada, we have a case that was recently decided, R.V. Chen, and I'll just drop it in the text here for people who are interested. This is a criminal law case where a dog was abused quite badly. It was a puppy. And the judgment, it was about sentencing, and the judgment said, in addition to some other positive things, animals are sentient beings that experience pain and suffering and must be treated as living victims and not chattels. Smashing a pet through a window is not the same as smashing a window. Okay, animals feel pain and suffering. They're not merely property. So it's a great example of just a very recent contemporary case, which is really recognizing this idea that animals can be the victims of crime, and in part because they can't communicate their suffering, that puts them in a special place, a special location. Okay, so there are a wide variety of ways then in which the law already is and certainly is continuing to recognize that whatever form of property non-human animals are, they are not like regular movables. As personal property, as designated, as many of you know, in the civil law. It's worth thinking about that word, the French word, meuble, in addition to meaning movables in legal terms, also means furniture. And the idea that is becoming increasingly recognized is that non-human animals are not the same as a table or chair, meuble, or furniture. Why? Because they're sentient. So that's just gathering together some of the examples on the personhood side to say this quasi-status already exists really in a way. Now on the personhood side, here, the idea is that, and this is really taken from the work of Cass Sunstein in the US, who some of you may be familiar with some of his work on animals. Non-human animals already have some rights. They have welfare rights in many countries. So in a way, then, they are already a legal person of some kind, in this empty vessel sense of being a legal person. I hesitate over this a little bit just because the welfare rights for non-human animals in Canada are really bad, actually. And this is an instance where, you know, people think, oh, we always think, oh, Canada's so much better than the US. But on this front, I would say we're actually worse because we don't even really have welfare standards. We have these codes, they're farm codes that set out like some things that would be desirable to do, but they're not enforced, and industry writes them and they're not even required. So there's really very, very poor welfare standards. But we do have in the criminal code protection against unnecessary suffering and provincial legislation that protects too. And we do have some protections. It's just on the welfare standards front, we are really, you know, and nowhere near the UK, where I know many of you are. Okay, so this personhood side then, where, you know, at least in many countries, we've got pretty robust welfare rights, then that is implicitly recognizing that those non-human animals in those jurisdictions are already legal persons of a certain kind, just in that empty vessel sense of legal personhood. And the suggestion then is to think of them and think of this as quasi-personhood. This doesn't mean sort of human being. It only means a being or entity capable of holding rights. Okay, and then these rights can be small or simple rights, or they can be capital R fundamental rights. So if you think of something like the 5 freedoms, which of course comes from England, as many of you know, that's the freedom from hunger and thirst, freedom from discomfort, freedom from pain, injury, or disease, the freedom to express normal behavior, and freedom from fear and distress. These are usually thought about as welfare rights or mere welfare rights, but they're also pretty fundamental. So if you take something like hunger and thirst, you know, it really seems to be, you can't get to be more important than that. Now, freedom of movement is something I think that is especially interesting. So that also really spans the kind of welfare, small r, to fundamental, capital R spectrum, in the sense that you can be talking about movement as minor as, you know, gestation crate being able to turn around, or you could talk about more meaningful movement or liberty in a sanctuary setting where the animal is going to be doing what it wants to do and not being exploited for human purposes like entertainment. Now, whether these rights, you know, what distinguishes them from being simple or small r or fundamental capital R, you know, are they indefeasible? Are they impenetrable? Are they, you know, are they inviolate, or can they be overridden? You know, human rights for human beings even can be overridden. So this is a, you know, ongoing debate, and you know, very rich debate. And I think all of that really can just continue to take place, but alongside this recognition that non-human animals are already on at least the quasi-propertyhood, at least the quasi-personhood side. Okay, so purely as a descriptive matter, then, there's a lot of evidence for non-human animals as at least having a quasi-personhood, the ability to bear rights, while still being property that is at best quasi-property. Okay, being more, and that is at least being more than mere property, more than a chattel, personal property, or a movable meuble. Now, interestingly, I recently learned that in Spanish law, there is a more specific category of movable. And if anyone in the audience knows about this and can help me out with this to talk about it a bit further, I would be very appreciative. It's called semoviente. And that is property that is capable of self-movement. And interestingly, just like meuble also means furniture in French, semoviente also means livestock in Spanish. So there's a, there's a literal meaning for it, and then there's also this legal use. Okay, and so that's in civil. In common law, Blackstone talks about property with a fugitive nature, and he, if people are familiar with this passage of Blackstone's commentaries, fire, light, air, and water are those things that have a fugitive nature. He puts animals in with other chattels personal, that are things movable. He says that they are annexed to or attendant on the person of the owner and carried about with them from one part of the world to another. Okay, and he puts animals in with household goods, or what he calls household stuff, money, jewels, corn, garments, anything else that can be put into motion and transferred from place to place. So there doesn't seem to be a separate subcategory for property that moves themselves in the way there is, at least in Spanish civil law. I don't know if it's in French civil law. I have looked around a tiny bit about this and I can't seem to find anything. But again, if anyone knows, that would be very helpful. Blackstone, though, does recognize that animals, unlike inanimate chattels, are personal in possession. They have in themselves a principle and a power of motion. And unless particularly confined, they can convey themselves from one part of the world to another. So even if like there isn't a concept there in terms of a word, the idea is still there, that, okay, they've got this ability to move themselves around. And this is when he then gets into the subcategories of wild and domestic animals. You can only have absolute property in the domestic animals. The wild ones are the fere naturae, and these are the ones in which you have only a qualified property. So here, I think, Raphael, we didn't put this in the bio, but one of the things I've done is written a big long book on this American property case called Pearson Imposed, which is about the capture rule. So it's about animals fere naturae and wild animals and how you reduce them to possession. And the idea here is really, you only can do that, this is called the capture rule, if they can't escape. And if they escape, then the title, it's what's called a defeasible title, it's defeated. And that's really so far as Blackstone goes. But if we think about this, all animals really, except ones that have died, can escape. And so arguably, at least, all of these should fall back into fere naturae, possibly. And in such a state, they could be said to own themselves. So that's an argument, it's not a very traditional argument, that argument, but you can make it based on, what we think of as those very traditional conservative sources. Okay, and I offer it here just in the spirit of sort of seeing, well, there is wiggle room in a universe, even as colonizing as Blackstone's was. Now, I must say there is a bit of a caveat here around freedom or escape. Generally speaking, I think, it's a very illusory thing, especially for non-human animals. I just happened to be listening last night to a program on CBC radio here, Canadian Broadcasting Corporation, called Ideas, where they were talking about, and they were talking to a woman who had grown up under communism in Albania. And she was saying, oh, freedom of movement, that's one of the things they wanted so bad, to be able to just leave the country. And so when communism fell, they got the ability to do that, to leave. But then she said the problem was we had this freedom to leave, but there wasn't a corresponding right to be gained entry by other countries. And so there was this illusory nature to it, even for, for humans, and certainly is there for non-human animals also. But we can, though, think of things that are nonetheless meaningful for non-human animals, like that involve movement, like the choice between moving away from something or someone that you don't like in your conditions of confinement, engaging in natural behaviors. They're also connected to movement are things relating to being transported, for example, to slaughter, and then also movement. And it's really on a spectrum, I think, from gestation crate to sanctuary is probably the type of thing that we're talking about. Okay. So what are we trying to do with Quasihood then? Just create some wiggle room here. And the suggestion is that animal advocates and animal scholars can try to zero in on this and in a way use it to decolonize our minds in a sense. So if, Gordon is right about those categories, we can't, and our bones, we can't really get them out of our bones. And, there's an argument to say that we don't want to, at least when it comes to personhood, because it brings rights with it. So we wouldn't want to get rid of that at any rate. But those concepts themselves are admittedly colonial and anthropocentric. Unfortunately, the legal system is colonial and anthropocentric. So the idea is, well, you can't get rid of them. So how about we reformulate them in a way that is more friendly to animals? Okay, so then we would be emphasizing how non-human animals are caught between being more than property and less than a full person in the human being sense. Now, Bénédicte Boisseron, who was a scholar who came to talk when we had the last animal law conference there just really recently, she's written this book, Afro Dog, Blackness and the Animal Question, which I would really recommend to people if you haven't seen that yet. It's a really great book. And she says here, what she characterizes as the humanist paradox. And what she says that paradox consists in is struggling with the knowledge that animals are not like things. Okay, so we know that they're not mere property, but the continual practice of treating them as such in spite of that knowledge. And that is really what we do. That's where we are. Our categories that we usually use, property persons, that binary, it's got to be one or the other and it can't be both, and it's mutually exclusive, that it does not capture this humanist paradox, what we do. Okay, and there is different ways you could translate that into legal terms, but this quasi idea is one way of doing it, and just in the sense that that would be something that lawyers and judges would, sort of recognize and understand that the exact specificity of it is left to be determined, but that could work as a framework. So quasihood then is an invitation to stop insisting that it can only be property or persons. That's on the normative side of the argument, while also providing a way to stop doing it on the descriptive side. Now, there are a number of criticisms that can be made of this proposal that, I have been raised when I presented in another forum, and also, just thinking myself about it. People in the audience might want to pick up on this, or I would be very interested in hearing what you think, which is, this as a description is very consistent with the status quo. I'm presenting it here as a strength that, well, non-human animals already are more than property, and they already are carrying a form of legal personhood in the empty vessel sense. And so is that, what does that mean then for the proposal? Is it just too consistent with the status quo? Another criticism that could be raised is that this idea, and I hadn't really thought of this actually until I had presented this at the Yale forum, the LEAP forum, just I guess that was maybe last December. And Doug Kaiser there had said to me, oh, well, that's good, but it'll only work for the higher order animals, a little bit like WISE and the Non-Human Rights Project itself, which is really very much what I'm reacting to. And so if that's the case, then that's worrisome to me, because I would like this to be an idea that can be used for all non-human animals. It's sort of one of the big criticisms of that approach, I think, is that only certain of the animals are going to get in. And that wouldn't be good. Although there's nothing in it itself that would dictate that or determine that, but there's certainly the risk of that could happen, or that it could end up getting mapped on to kind of hierarchy of species, sort of like the Great Chain of Being all over again. That's possible. I also wanted to say just a few things in closing here about the idea that I think it's consistent with Visa Kirky's idea of the bundle or cluster concept of person. I didn't know Visa Kirky is presented in this series earlier. Also, Eva Burnett Kempers and her alternative rights paradigm, same thing. I think Quasihood is pretty compatible with that. And in fact, when I connected with her on LinkedIn, she said, oh, you're joining the growing group of people who think that it doesn't have to be one or the other. So, so that was nice. But really, yeah, that is really the gist of the idea that property or persons are not all or nothing or one or the other. And there can be incidents of legal personhood that, maybe we're talking about things that are indefeasible, maybe we're not, but but we don't just have to confine ourselves to one or another. I actually am going to be publishing review essay of Kirky's book, and I discuss Bernadette Kemper's work in there as well in the Journal of Animal Ethics. That should be coming up pretty soon. But if anybody in the audience would like it, I'd be happy to send you a draft of it. Okay, so in sum then, the binary for non-human animals is, in my view, really a trap that animal advocates and scholars ought to resist. Why? Because it sets non-human animals up for failure, at least for right now. And Quasihood is a realistic way to resist while simultaneously problematizing what we think we know about these categories, if only because when you say it or write it, people are going to go, what? What's that? You know, and then, you know, the idea is, okay, but it's partaking in both, but it's not fully one or the other. Okay, that's great. Raphael, I don't, is that could we leave it there and open it up?